Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association, section of Environment, Energy, and Resources. This episode is part of our SEER100 series, celebrating 100 years of the section.
Professor Richard Lazarus is the Charles Stebbins Fairchild Professor of Law at Harvard Law School. In addition to teaching, Professor Lazarus has represented the United States, state and local governments, and environmental groups in the United States Supreme Court in 40 cases, and has presented oral argument in 14 of those cases. He has published 3 books on the development of environmental law, both through statutory development and through litigation brought before the Supreme Court. In addition to his academic work, Professor Lazarus was the principal author of the report to the president of the National Commission on the BP Deepwater Horizon oil spill and Offshore Drilling Commission, for which he served as the executive director. And I will just add, as one of his former students, he is an incredible law professor, mentor, and a wonderful, wonderful human. Thank you so much for being here with us, Professor Lazarus. So excited to talk to you.
Oh, thank you, Lindsay. I'm delighted to be here and to have a chance to talk to you as well. Looking forward to your questions.
So, the focus of today's podcast is to talk about the change in environmental law with a view through the Clean Air Act since its inception and through the present. So, my first question for you, Professor Lazarus, is as an undergraduate student in the early 1970s, turned law school graduate by the end of the decade, can you share your experience of beginning your career in environmental law alongside the regulatory development of it?
Absolutely, Lindsay. Delighted to do so. So I made a very lucky guess as a 17-year-old. I literally decided in the spring of 1972, at age 17, I wanted to be an environmental lawyer and I wanted to be an environmental law professor. I was trying to come up at the time with what I wanted to do with my life, literally. And I tried to figure out a way to combine two things, something I could care a lot about and something I could be really good at. I didn't want to do something which I cared a lot about and wasn't any good at. I didn't want to do something I was really good at but didn't care about. So I picked really environmental law, hoping to be a teacher. It was so early in the development of environmental law that when I ran into college classmates and they say, "Why are you majoring, getting a degree in chemistry? And why are you getting a degree in economics?" I said, "To be an environmental lawyer." Most would say, "What's that?" It just wasn't even a word in popular sort of dialogue at the time. And that's really what I did. I immersed myself beginning in 1972. EPA had just been created. The Clean Air Act had just been passed. NEPA had just been signed in the law. The Clean Water Act had not yet even been passed. It was going to pass in November later that year. And I've been immersed in it ever since. And it's just been fabulous. It's a fabulous ride. But to be there sort of at the beginning and to continue to be immersed in it for basically 55 years has been a huge treat and sort of the foundation of everything I write about and how I teach the class as well.
You know, just in thinking about you kind of being there at the forefront and at the beginning of everything, I'm wondering if, as you were saying, not everyone knew what an environmental lawyer might be. It wasn't part of the lexicon at the time. And I know that from your book, The Making of Environmental Law, that some people might have seen environmental law as kind of a passing fad, maybe not something that would have longevity. I'm wondering if you can, kind of speak to how that mentality has shifted and maybe, whether you see this fad hanging on for several more years.
Well, I certainly hope it hangs on for more than several more years. But you're absolutely right. I remember I was a bartender at the Ramada Inn in Champaign-Urbana, Illinois, after I made the decision. At that point, I had to be 21 to be a bartender. And I mentioned that I wanted to be an environmental lawyer to a local official at a local plant, a Humco craft plant. And he looked at me and said, "That's a flash in the pan, a fad." And I kind of thought to himself, I was polite because I was a bartender, so it was a service industry. But I thought to myself, what an idiot. And the truth is, he was actually more wise than I was in my naivete, thinking this was necessarily here to stay. It turned out I was right, but there was a lot of force to his intuition at the time. I don't think environmental law really became more settled in the legal landscape until the 1980s. And that's when Superfund passed. The
Mhm.
Superfund passed, everyone needed an environmental lawyer. So every law firm in the country started to hire environmental lawyers. Every corporation, small and large, needed environmental lawyers as well. The environmental law of the Department of Justice exploded. EPA exploded in hiring. The National Environmental Group started hiring more and more than they ever did before, partly in response to the Reagan administration. But it was the Legal Liability Superfund which really made it part of sort of settled law, as everyone had to comply with it. Give you one measure I always like to use. When the administration Jimmy Carter ended in 1980, there were about 12 to 13 attorneys in the Environmental Enforcement Section of the Environment Division, U.S. Department of Justice. 12 years later, at the end of first Reagan and then Bush, there are about 150 to 170 lawyers in the Environmental Enforcement Section of the U.S. Department of Justice. And that was just, right, an expression, reflection of what was happening nationwide. So I think the 80s is when it really settled, and it's been settled ever since.
In terms of thinking about that settling in the 80s, do you think that some of that is what led to the amendments to the Clean Air Act being passed in the 90s? And can you speak to maybe, I think for some of us newer to the practice of environmental law, we've seen a lot of kind of shifts back and forth politically, but it really appears through the 70s and then with the 1990 amendments that there was some real bipartisan strength and effort put into updating the Clean Air Act. And do you think that that built off of that 1980 kind of foundation and solidarity, or do you attribute it to something else?
Yeah, I think it's sort of related to it. It's a really interesting story. You're right. The 1990 Clean Air Amendments are a sort of foundational law, one of the most ambitious we have in the country. In the 1970s, when they first passed all these laws, sort of law after law after law passed 1970s, really demanding pollution control laws, really far-reaching aspirational natural resource conservation laws with no opposition in the House or the Senate, just passed by overwhelmingly bipartisan majorities. Environmental law then faced its real first test in the 1980s because Ronald Reagan ran for office in 1980, sort of saying that environmental law and laws like that were a problem, and he wanted to significantly cut back on them. And he put in charge of the sort of most important agencies, Ann Gorsuch at EPA, James Watt at Interior, and in the beginning he had a majority in the Senate as well. But almost none of the Reagan reform efforts worked. He was a very immensely popular president, still a very popular president. He couldn't get any of those reforms through. There was a major rebellion in public opinion against cutting back on the laws. The public had been persuaded by the 1970s. Leading Republican leaders in the Senate were against the change, and Reagan had retreated. And Gorsuch was essentially fired or resigned. James Watt was basically fired but resigned. And during the 1980s, the laws got stronger than ever. It became so much a coalition around more stronger environmental laws that when Ronald Reagan's vice president, George Bush, ran for president in 1988, he said, "I'm going to be the environmental president." And he campaigned against his Democratic opponent, Michael Dukakis, on how dirty the Boston Harbor was and put out a national ad showing how dirty the Boston Harbor was. He was the first one ever to run for president who ran actually as an environmentalist. And he promised in his campaign platform to basically pass a new Clean Air Act. Everyone knew we needed a new statute. The last one had been in 1977. That was 13 years old. We had the big problem with acid deposition, then called acid rain, which was the logjam, unable to pass in Congress. And Bush came in. He appointed Bill Riley as head of EPA with fabulous environmental credentials. And they championed, the White House, they championed passage of the Clean Air Act, an enormously ambitious, demanding, far-reaching law. We didn't know at the time that would almost be the last environmental law passed. We haven't really had one pass of that kind of significance since 1990. And that's a good, what, let's say 36 years later? We don't have it, but it was a hugely ambitious law, and it was the country coalescing around it, passed again by overwhelming bipartisan majorities.
You said something that took me back to law school days a little bit there about the Boston Harbor. I remember on one of our first days in environmental law class, you showing us photos of Denora and the Cuyahoga River and London smog. And it really presents this issue of environmental concerns happening locally and how you can make changes to help your local community. But I think, something that we've seen in recent decades is more of an outward turn internationally with climate change issues and realizing kind of the global impact of actions. And I'm just wondering if you can speak to, from your perspective, how you have noticed that shift from the more kind of local community concerns to this global focus that I think a lot of folks now have, and just kind of what you make of that.
Yeah, you're certainly right. Issues like Superfund in the 1980s was all about local. You have abandoned active hazardous waste sites around the country. You have the national priority list. So it's very focused on local issues, safe drinking water on local issues as well. Air toxics, local. Certainly water pollution issues were local. There was one aspect of environmental law back in the 1970s, which had an international dimension, and that was actually the Endangered Species Act,
Mhm.
which passed in 1973. That was right after the aftermath of the CITES Treaty, the Convention for International Trade in Endangered Species, which was negotiated, and we signed it in the law basically at that time. The ESA was basically our domestic implementing legislation. So that's the one sort of little footnote to that localized nature of environmental law. But you're right. Since about the late 1980s and the 1990s, climate change has driven this international focus. And that's because you cannot address climate change effectively without international approach. The pollutions, as we know, the greenhouse gas pollutants go up in the atmosphere. It doesn't matter where in the globe they come from. They all create one uniform concentration around. So unless you control all those sources around the globe, you can't possibly control climate change. So that's been sort of a driven international focus, and it's one in which we've stumbled on. We actually passed some very important international domestic legislation, and we've stumbled internationally as well. In the 1990s, we saw when the U.S. went out up negotiate the Kyoto Protocol. We didn't actually actually enter into it because there was basically a vote in the Senate, a sense in the Senate on the Kyoto Protocol. The vote was 97-0 against the Kyoto Protocol, and that's because it was international, and people in the United States rebelled against the idea of international agreements and something which would bind the United States to make us oblige to other countries in the world, somehow ceding our sovereignty. So we've stumbled tremendously on the international dimension of environmental law, and climate change has been, I think, the main stumbling block.
So if we think about, trying to address climate change domestically, I wonder what your thoughts on, the Clean Air Act and whether its current framework, can helpfully allow for the regulation of something like greenhouse gases. If you think that the current framework can properly try to regulate that and address climate change concerns. There's other pollutants that I think are getting attention now in different spaces, PFAS, forever chemicals, microplastics. And I would just really appreciate your thoughts on whether you think the current framework we have, you've pointed out it's been 36 years since we've had major updates to it. Do we think that it's still able to handle kind of the issues of present day and tomorrow?
Yeah, I mean, laws like the Clean Air Act and the Clean Water Act, which was last amended in 1987, so even longer ago than the Clean Air Act, the language is written with sufficient capacity. It's very capacious language that it does confer legal authority on EPA to address new issues like greenhouse gases and like PFAS pollutants, but not well, far from ideal. The statute were written not with these kind of pollutants in mind, especially the greenhouse gases, but to a large extent PFAS as well, present different issues. And this is one of the great tragedies of environmental law. And that is, you look in the 1970s, 1980s, you had a fully active Congress, a Congress which responded as we learned more about the pollution, what worked, what didn't work, which regulatory programs worked well, what didn't work as well, learn from industrial experience, learn from state experience, learn from EPA agency experience. And every few years, the laws would be revisited and changed. Sometimes retreat a little bit in light of information, sometimes push harder in light of information, but it was a fully active Congress working with the executive branch, responding to judicial decisions in a highly interactive and iterative process, dynamic. And that's what environmental law needs to be in light of new scientific information and new economic and policy priorities. So it's one of the great tragedies that Congress has basically completely abdicated its authority and its responsibility to make environmental law since 1990. It's the branch of government. It's the Article 1 branch. For the kinds of tough decisions that need to be made, they should be made in the first instance by the executive branch. They should be made in the first instance certainly by the judiciary as well. But as long as Congress drops the ball, what we've had happen ever since then is federal agencies, whatever the administration, have had to work with increasingly old language. They've had to take that language and try to blur it and push it and shove it a little way to try to make it maybe more demanding than one administration, a little less demanding than others, but it never really fits. It doesn't fit well. The actual issues become more and more sort of separate from the clear text, which empowers the courts to try to figure out what to do about it, and increasing years to question whether the agencies can do these things with text becomes a little less and less on point, a little more stretched. So we can do it, but it's not ideal. It's not the right way to make it. We need national legislation which actually thinks about climate law and makes the necessary trade-offs about greenhouse gases, makes the tough decisions, doesn't abdicate it to a federal agency to do. We may think on PFAS. PFAS can fit. Of course it can fit. It's clearly a pollutant, and the Clean Water Act is written expansively like the Clean Air Act, but it's not the way to make law. So it's actually a huge problem we face. And right now, with the Supreme Court, which is demanding in recent years, we want clear and clearer textual support for what the agencies and the executive branch want to do. We have a real problem because at the same time that the court is debating clear and clear textual authorization, we have a Congress which is still not passing anything. And it's leaving the agencies more and more at sea, and these important pressing problems like PFAS, which can be very local and have very dire health consequences, and issues like climate change, which has potentially catastrophic consequences, but is global in nature, it puts the executive branch very much unable to respond effectively.
I really like that you brought up the judiciary, and I think as anyone listening to this podcast knows, you have written extensively about the role the Supreme Court has played in the development of environmental law. And I think, just considering what you were saying about Congress's inaction, I think has allowed more cases and controversies on environmental law to reach the Supreme Court than it had previously. So I'm wondering if you can share with us your thoughts on the Supreme Court's role historically, what it's been more recently, and what you see it as being moving forward.
Yeah, you're exactly right, Lindsay. Now, the environmental law has never sort of enjoyed a sort of progressive, welcoming court to its ambitions. If you think about it, modern environmental law starts sort of in the early 1970s. That's just when we're pivoting from the Warren sort of liberal court to the Berger, more conservative court. Richard Nixon, in his first term, had 4 nominees to the court in 4 years, including a new Chief Justice, Warren Berger. So the court has always been conservative since the get-go for environmental law. For basically 56 years, it's been a conservative court. With that said, it was still a court that was sort of win some, lose some for environmental plaintiffs, at least. They won some big cases, they lost some big cases. And the issues were always in play. There was always a center of the court, even though it was conservative center. It was the center of the court which could decide cases one way or the other. Justice O'Connor, Justice Kennedy in particular. Justice O'Connor gets in the court in 1981, Kennedy a few years later, and they basically determined the majority. They had conservative instincts. They were worried about business. They were worried about federal government overreaching, but they understood the need for strong environmental laws still, and sometimes they vote one way, sometimes the other, but they decided. And so the court was a conservative court, but it was ultimately a fairly balanced court, not aggressive in one way or the other. That all changed when Justice Kennedy left the court in 2017. After that, and certainly when Ruth Bader Ginsburg passed away in 2020, we've had a decidedly very conservative court, which has expressed sort of real skepticism to the efficacy of environmental laws that demand a lot of the business community, and they believe lack clear contextual support. So we've seen the last several years major loss after major loss, at least for those who, want strong environmental protection laws. For those who think the environmental protection laws have overreached and been too unduly harsh, they welcome these decisions. But think of the cases in the last several years, right? We had the Clean Air Act, the West Virginia case, announcing the major question doctrine. We had the Sackett Clean Water Act case, which dramatically cut back on the geographic scope of the Water Act. You had Loper Bright, the Magnuson-Stevenson Fishery Act case, which basically overturned, right, the Chevron case, a major Clean Air case, which had been sort of the administrative law blueprint for environmental law for decades, since the mid 1980s, overruled as well. You had the City of San Francisco Clean Water Act case. Again, a significant loss there for expansive reading of water quality standards and permitting under the Clean Water Act. You have the seven county NEPA case, which significantly cut back on NEPA. They called it, right, a course correction in Justice Kavanaugh's opinion for the court. But it's a course correction, which is correcting the course set out for NEPA in the 1971 decision in D.C. Circuit by Judge Kelly Wright in the Calvert Cliffs case, the foundational case for that. So you have the Clean Air Act cut back on significantly. The Clean Water Act cut back significantly. You have the National Environmental Policy Act cut back significantly. You have a Chevron overruled. That's a lot. That's a mouthful. And that's just, right, in the last several years. So the Supreme Court has significantly changed its tune in environmental law, and we'll have to wait and see what happens next. There's some big issues likely to get before the court in the not too distant future.
So we've spent a lot of this discussion so far focused on federal environmental law, but one of the developments since the 1970s is really the growth of environmental law across all 50 states, some state agencies taking bigger action than others. I'm wondering, from your perspective, what impact the development of state environmental protection has had on environmental law as a whole.
It's a great question. I always think of environmental law this way. It's an upside down pyramid. And the federal environmental law is at the bottom, little bottom triangle, but most environmental law is state and local. So that's been the case for decades. We focus on the federal. In my class, I focus on the federal, but actually most environmental law is state and local in nature. But the way it historically has worked is it gets a lot of its energy, actually a lot of its literally financial resource support from that little triangle at the bottom. A lot of it is built upon the foundation of federal environmental law. What is changing right now is the extent that the federal government is stepping out of the role in several ways. I can think about climate change as one, environmental justice in the last several years is another. That top part of the pyramid, the bigger part, is acting more and more independently of the federal government. A lot of states are stepping up to enact sort of more aggressive climate change laws, ones involving mitigation, ones involving adaptation of climate change. Obviously, like the climate superfund laws that some of the states are doing are examples. The portfolio laws designed to have their electricity produced by using more renewables are examples of path grading laws. In environmental justice, the federal government's stepping back a lot. 14 states in 2025 announced a new coalition that they would push, advance, and do more aggressive state environmental justice rules. Illinois has done that. Colorado has done it. A whole bevy of states have enacted more aggressive environmental justice laws as well. So I think state and local laws have played a major role for a few decades. Now they're playing a more innovative and path-breaking and independent role than they have historically in the country.
So with other states taking more of an independent path, and I really like how you mentioned the climate change regulations, there's portfolio regulations, and they can be different across, different states. But I think something that you have talked about in the past is industry and the regulated communities really prefer stability in a lot of ways, especially for companies that are making plans 2 and 3 years out. They like, the stability and knowing what they're going to have to comply with. And so I'm wondering if you have thoughts on how that need for stability within the regulated community can lead to changes or development in environmental law.
Part of this harkens back to what you asked me before. When did I think that environmental law became more settled? Less the radical disruptor, which it was in the 1970s, more part of the settled legal landscape. By the end of the 1980s, it was a settled part of the legal landscape. We had a gazillion-dollar pollution control industry in the United States. These are companies who make their money, they make their profits, right, by addressing pollution issues. We had a lot of industries dependent upon clean air and clean water, whereas the real estate industry, the silicon chip industry, whereas the fishing industries, they all realized they had economic value based upon it, based upon the environmental protections. Then you had a lot of companies which had invested billions of dollars, or hundreds of millions of dollars, in pollution control equipment, and it worked. And they were still making good money as a result. They didn't necessarily want to see those laws go away to make unproductive their investments. Certainly, if it meant their new competitors would have a competitive advantage over them. So you had an industry getting more and more conservative about laws that were sort of destabilized. Most companies prefer a strict environmental law, which is stable, so they know how to make their business investments, than a weak environmental law, which is unstable and which changes with every different presidential administration. They can't make investments. So having settled law, environmental protection law, is crucial and very important in industry. A lot of the change being driven now is not being driven by industry. It's driven by ideology. Industry has nothing wrong with wind power, solar power. They're all in favor of it. They can make a lot of money with it. They can get more reliable energy supplies from it. So the effort to undo those is more ideologically driven. I remember a good friend of mine during the oral argument in Massachusetts versus EPA gave the argument with a guy named Jim Milkey, who was Assistant Attorney General for the Commonwealth of Massachusetts. His wife happened to sit in the audience, not happened to be, of course she was sitting in the audience of the Supreme Court during the argument, but she had to be sitting next to some auto executives. And when the case was done, they gave her 2 thumbs up because they said, "Hey, your husband did a great job in the case." But what would they then remark to her is even more telling. They said, at the end of the day, we don't care. If there are more electric vehicles, we're still gonna make money. We can make money one way or the other. Give us the rules of the game, we'll build the car, we'll make money. And that's often how industry feels. Give us the rules of the game. Don't keep changing them. You didn't see the auto industry, right, pushing Donald Trump and the rest to cut back on the tougher greenhouse gas emission reduction standards for motor vehicles. They were doing well under the old rules. They were making money under the old rules. But as the rules change, they have to change too. That costs a lot. They threw away a lot of investments. So yes, I think settled law is good for business in all kinds of ways. Those who have to comply and those who make money off the compliance because they build the equipment, those who depend upon the clean laws. And right now we have startups around the country who are trying to make the better solar collector, the better hydrogen cell, right? The more efficient transmission lines, because they know that's the future and they want to make a gazillion dollars by having the best product out there to address it. And the current administration, not for worse, not for better or for worse, but for worse, is destabilizing that burgeoning business economy.
So, as we're nearing the end of our time, I wanted to ask you, as an environmental law professor who is routinely engaging with students, hoping to embark on a career as an environmental lawyer, what advice would you have for new attorneys who might feel like entering this space right now is a little difficult, that there is some of that uncertainty? I'm wondering if you have any thoughts that you would like to share with some of our newer entrants to this career path listening to the podcast.
Yeah, happy to do so. So here's what I tell my students right now, and I love my students. I basically say this: look, you want to be an environmental lawyer? Well, guess what? It's the perfect time. If you're expected to be sort of passive, back, mechanical, just working with existing laws, uh, it's the wrong time for you. The stakes right now are huge. The importance of the work you can do in your career is massive. So if you're upset about things that are happening right now, get off the ground. stand up and get to work. Because the fact is, you're the future. We're going to need a huge amount of great environmental lawyering work in the next few years and the next decades. It's going to take the most creative minds to build back the foundation of environmental law, which is being unraveled right now. The problem with climate change is not going to go away. The problem with PFAS pollution is not going to go away. The problem of environmental justice is not going to go away. They're going to be there, even if they're ignored now and not fully addressed the way they should be. They're going to be there, and it's going to take the best minds and the best work to get it done. And I tell my current students, you got at least a 50-year time horizon before you. How exciting is that? What great things you can do in your career. What opportunities you're going to have before you. I find teaching the students right now one of the most inspiring things that I do. When I get worried time to time by what has happened here or there, I see these things I've worked on and cared about for 50 plus years be unraveled by the current administration. I look at my students in my class, I'm hopeful, I'm inspired by them. So I think it's a challenging time, but it's a great time to be an environmental lawyer. If you want to do important things in your life, you want to find something that you can be good at and care about it, environmental law is as ripe for the picking now as it was when I sort of commenced down this pathway back when I was 17 years old in the early 1970s.
I think that is a perfect note to end on. Thank you so much, Professor Lazarus. We really appreciate you being here with us.
Thank you, Lindsay. I'm delighted to do so.
We hope you enjoyed today's episode. New SEER100 series episodes will be released regularly through August 2027. So be sure to check back for more conversations exploring the people, ideas, and issues shaping environmental, energy, and natural resources law. To learn more about the section, visit americanbar.org/environ. Please check where you found us for future episodes. Thank you for listening.